I am very, very honored to introduce you to Penny White, Justice Penny White, who is the E. Overton Distinguished Professor of Law and the Director of the Center for Advocacy and Dispute Resolution at the University of Tennessee College of Law. And Justice White earned her law degree from the University of Tennessee and the LLM. I always have to, my daughter's an attorney. I never remember what that stands for. What is that, Caitlin? Well, Justice White will remind us when she gets up here. It's a master's degree, correct? Right, at Georgetown University Law Center. And we were so pleased that she was available tonight to talk to us. Her reputation is just immense around here. And we're, of course, the topic that she's speaking on tonight is also very close to the hearts of league members. The fair justice system is something that we have seen come under threat in our own state and around the country, and I'm just personally really, really thrilled to be able to hear her. But she has, as I said, a very, very eminent background, having argued successfully a case before the Supreme Court when she was in private practice. She has served as she's been a judge, the first woman circuit court judge, and you'll see this in the notes that we have in your program, the second woman to serve on the Tennessee Court of Criminal Appeals, and the youngest person to serve on the Tennessee Supreme Court. She also has an outstanding academic background, having received awards for her teaching and her writing excellence, and I understand that students are very praiseworthy of her in her work at UT. So she does other kinds of training. I read online that she and her partners are quite entertaining as they put on their their trainings in ethics and other topics for judges around the country. And she also teaches courses on as the capital punishment, and I may not be saying that correctly, apologize. But anyway, I just want all of us to give a very warm welcome to Justice Penny White.
Thank you very much, Jamie. Thank you, and thank you for having me tonight. I appreciate the opportunity. Let's see if I can make things work. That would be nice. So tonight, I want to talk about a concerned citizen's role in securing. Notice I didn't say in maintaining. I said in securing fair and impartial courts. And I am grateful to talk about this topic. It's near and dear to my heart. And I know that in this audience of very concerned and well-informed citizens that it's really not necessary to spend much time talking about the importance of a fair and impartial court system. But just by way of historical refresher, let me begin by reminding everyone that our democracy was purposefully flanked by three independent branches of government, separate and independent, with reciprocal checks and balances. So for context of tonight's topic, I want to begin there and remind you, and you know, every time I start talking about this, I kind of hear some patriotic song in the back of my head, and it's because it really is profound that among the reasons that this nation was founded was to secure independent courts. And just to put that in context, when the founders came across to begin this country, they wrote a list of grievances that they had against the king. And prominent in that list, the way I like to put it, in the top 10 in that list was their concern that King George was controlling the courts. And they stated it this way. They said he has made judges dependent on his will alone for their tenure in offices and their salaries. And it was so serious, and I mean this very respectfully, that people were willing to die for the cause of having, among other things, a fair and independent court system. So in addition to the overall framework for the nation's three branches of government, there was a deep, abiding desire that the country be based upon a court system, an institutional court system that was free from the control of the executive branch and from the other branches. And, additionally, again, just by way of refresher, our founders were confident that the court system would be independent, but to just add an extra layer of protection, they decided that it would be important to have a dual system of government, where most of the rights were preserved for the states, including the states' rights to decide how to set up their own justice systems, but where the federal court system was sort of an extra layer of protection, particularly with jurisdiction over some of the more difficult cases, some of the cases in which courts might tend to be placed under political pressure. So for that added protection, those federal judges were given life tenure. And never did the founders anticipate that state court judges would have to have life tenure. They anticipated that the federal courts would add that additional level of protection. But it was important to know that not only did they find it essential to create an independent court system, but to also give this federal court system that added layer of protection, life-tenured judges. So from this kind of brief refresher of history, I want to turn to a quick literary reference, not historical at all, but historical from a literary point of view that places our discussion in context. And this comes from Atticus Finch, everyone's favorite fictional yet revered lawyer. And when Atticus was speaking about the courts, he had this to say. I just absolutely love this quote. He says, "In this country, the courts are the great levelers." He says that's no ideal with an L. That's no ideal. That is a living, working reality. And that statement is really the overriding theme of what I want to talk about tonight. That our justice system become perhaps in some people's minds, but become and remain the great leveler. And what do we mean by that? I mean to level regardless of the political clout of the parties, to level regardless of the financial resources of the parties, and to level regardless of the stature of the parties, to apply the rule of law indiscriminately, to level, as Atticus would say. So it's not only important that courts level in order to preserve the rights for those who are not favored in our court, or not in the favored class, but also those who do not have the resources to secure their rights protections. But courts also have to level, and I think this gets missed a lot in the discussion, to assure the economic stability of our nation. Courts have to be trusted to fairly mete out disputes in order for business to thrive. And it doesn't take a very far look across the world to see what I mean by that. Business and governments, as well as individual litigants, depend upon being able to turn to fair courts in order to receive justice. So, although our nation has both state and federal courts and an independent branch of government, independent branches of state judiciaries, the overwhelming number of disputes in this country are decided in state courts. Specifically in 50 plus 1, the 50 state courts in the District of Columbia, hundreds of judges, thousands of judges, deciding somewhere in the neighborhood of 850,000 cases a year in the state courts. in the state courts. And to put kind of a number on that, more than 95% of all legal disputes are decided in the state courts. And so that is my focus. State court judges, state judiciaries. So by far, the job of leveling in this country is the job of state court judges. So I want to go from that idea to the idea that, at least in my mind, it is not only important that courts actually do justice, but that they be perceived as doing justice. Justice Brandeis, I think it was, says justice is as it is perceived to be. So to me, the perception of justice is very important. In many studies, political scientists have studied the impact of negative perceptions of governmental institutions, including the courts, and have determined that courts as governmental institutions, or any governmental institution, will lose its ability to be vital, will lose its legitimacy as the public's confidence wanes. And numerous studies also indicate that the court's fairness, and thus the vitality of the justice system as a whole, is prompted by and in response to how individuals feel that they are treated by the court system. I want to talk about how 3 United States Supreme Court decisions have affected the perception and fairness of our courts. And while I accept that the public's confidence in the court ebbs and flows, it fluctuates over time, and it is affected by all types of historical events, I believe that these 3 decisions beginning in 2002 have had a serious deteriorating effect and will continue to have a serious deteriorating effect, and that the concerned citizen needs to know about in order to try to ameliorate that effect. You know, we live in a hodgepodge system of state judiciaries, and this chart, this map, which you can't read clearly, but gives you an idea of the different types of selection systems throughout the country. Merit selection, appointment, partisan and nonpartisan, and then some combination. So I'm still, I think, able to speak generally about how these 3 United States Supreme Court decisions have affected all state courts. So let's start with the oldest of the decisions, the decision known as Republican Party of Minnesota versus White, a 2002 decision of the U.S. Supreme Court. As is true of all 3 of these decisions I will talk about, this is a 5-4 decision of the court. 5 justices ruling one way, 4 would have ruled the other. And that in and of itself is staggering when you think about the impact. So I suppose it would be very important to talk about how people get on the U.S. Supreme Court as well as what we're going to talk about tonight. But in reality, less than 1% of the cases that the federal courts hear, and remember the federal courts only hear 5% of all disputes, less than 1% of that ever get to the United States Supreme Court. So in this decision, Republican Party Minnesota versus White, what was at issue was the Code of Judicial Conduct. And please, let me say from the outset that I know there are people in this audience who know this is information as well as I do. So forgive me if I appear to be educating you below and beneath your level, but I feel like it's important to get the groundwork laid for everyone. But forgive me, I don't mean at all to underestimate your knowledge. But this case involved a challenge to the Code of Judicial Conduct, which is a code that every state has that prescribes judicial ethics. In this situation, a candidate for the Minnesota Supreme Court, and you go back and you'll see, excuse me a moment, I hit the wrong button, that Minnesota is one of those states that elects its judges. A candidate for the Minnesota Supreme Court wanted to announce his personal views about political issues in seeking a position on the court. But the Code of Judicial Conduct in the state of Minnesota, and in most states, put some limitations on that, restricted him from announcing his views. Now, the particular provision at issue in Minnesota was not in effect in many states, but some similar restrictions were. But in Minnesota, this judicial candidate was disallowed from announcing his personal political views. He sued, and 5 members of the United States Supreme Court said that ethics provision violates the First Amendment. And their rationale was that when a state chooses to select its judges by some sort of political election, that they must be free to exercise the very basis of political expression, that being the right to say how they feel about political issues. Now, the 5th vote on that case was Justice Sandra Day O'Connor. And she concurred, but that made her the 5th in the majority. And her opinion lamented the harm that politicizing the state judiciaries would cause, but nonetheless agreed with the majority on the First Amendment. And it is so poignant that Justice O'Connor has spent her entire retirement backpedaling, but more importantly, crusading against the politicalization of the courts. And she said publicly on more than one occasion how much she regrets her vote in Republican Party versus White. So what was the impact of that decision? The impact, in my opinion, was that the decision enabled certain groups to be able to identify a candidate's personal political ideology. And the primary means by which this was done was through the use of questionnaires. Now, when I was on the bench in the 90s, we all got questionnaires, and we all answered the questionnaires the same way. We can't respond because the Code of Judicial Conduct prohibits it. That barrier to response has been eliminated. But what Republican Party versus White has also prompted is a kind of different sort of question. This is one of the most common questions. This is from the Florida judicial questionnaires, but they're all very similar. This is a very common question regarding the marriage between men and women or between people of the same gender. Another very common question is this: which of the current justices of the Supreme Court most reflects your judicial philosophy? Now, once the candidate is asked and answers the questionnaire, it then enables the group that has special interest to categorize the candidate. And this is a very common way that they do that. This is from Alabama. Alabama's had more chief justices than Carter has liver pills because of their elected system. So, and you have to be pretty old to understand that cliche, I guess. So you're telling your age by laughing at it. So as a result of the Republican Party versus White, judicial candidates can no longer stand behind the Code of Judicial Conduct. It is now a matter of personal choice whether they answer a questionnaire or not. They cannot face ethical sanctions for responding. Groups can now identify these so-called personal political ideologies, and based on those ideologies, make a determination as how they wish to funnel their financial resources. This concerns many people. This concerns the general public to the tune of 82% of the public, when surveyed, expressed great concern that these types of expressed ideologies are having an impact on state Supreme Courts and state appellate courts. So the point of view being expressed when a candidate is asked is the personal point of view of the candidate. Judges, after all, are supposed to decide cases based upon the law and the facts in a particular case at a particular time. So the point of view is the personal point of view, and that's stressed in the Republican Party versus White decision. But what message is implicit in the expression of a personal point of view with regard to what one feels about the viability of a fetus or the marriage of same-sex couples? What expectation is created among the general public when they read this expressed personal political view? Bookmark this point, please, because I want to return to it when we talk about what a concerned citizen's role, in my opinion, should be. So in addition to enabling groups to sort of ferret out individual ideology, the White decision galvanized these organizations. As much as any decision I can think of, it strengthened organizations whose agenda it was to reform state judiciaries. They undertook aggressive litigation strategies, and I've written about this and can give you much greater detail, but just suffice it to say that all over the country they filed lawsuits dismantling other aspects of the Code of Judicial Conduct. So what had once been a fairly restrictive ethical code became much diminished as a result of this litigation. Many states, rather than face being sued by this in these aggressive litigation, within these aggressive litigation strategies, just dismantled parts of their ethics codes on their own. And this not only opened the door for more aggressive campaigning by judicial candidates, but again, I feel that it has attracted an altogether different kind of judicial candidate, one with different motivations. Identifying a candidate's ideology enables a group to funnel money toward that candidate who shares their points of view. Now, whether there's a quid pro quo in that funneling is up to the candidate, but all of these candidates face subsequent elections, and so we have to wonder whether in their judicial decision making they're worrying about receiving those funds during the next election cycle. From 1990 until 1999, judges seeking judicial offices in state appellate courts, all told, spent $83.3 million. Following the White decision, and from 2000 to 2009, those same judges, same number of courts, same number of seats, $207 million. And that was not just in a few outlier states. In 20 of 22 states that elect their state Supreme Court judges, those states witnessed the costliest judicial race ever after Republican Party versus White. The 2010 tally for that year alone was $25 million. Now, you say we're sitting in 2013, but remember, most judicial seats are 6 or 8 or sometimes even 12-year terms. So the cycles are, so you can't see the extent of the spending by looking only at a 2 or 4 year cycle. In the last decade, I'm sorry, getting before myself a little bit. This slide shows you in that 9-year cycle who was spending the money. Business, lawyers, and lobbyists, and look at the tiny little portion spent by political parties and candidates, and that large portion by unknowns, which we'll talk about a little bit more. I know you can't see this, but the state at the top of the list is Alabama. In the last decade, the big spender was Alabama, where judicial candidates spent $41 million in one judicial race in 2006. 2 candidates in that race in Alabama, not that different from Tennessee, folks. 2 candidates spent more than $8 million. And I once had a high school student ask this question, and I think it's just about as dramatic a question as could be asked. He said, "How much do those justices make?" Yeah, about $130,000 or $50,000 a year, yet they're spending $8 million to gain the seat. Finishing slightly ahead of Alabama is Illinois, where 2 candidates running for a district-based Supreme Court seat spent $9.3 million. Now, what I mean by that is that was not even statewide. That was a downstate, not Chicago, a downstate Illinois race, $9.3 million. At the end of that campaign, the winner, Justice Lloyd Carmeier of the Illinois Supreme Court, said it was obscene. And he described it this way: "I never felt more like a prostitute than I did running for the Illinois Supreme Court." And he sits on the court today. He also wondered, as I wonder, how does it serve the people? How can they have faith in such a system? How indeed? A strong majority of the public feel that perhaps we cannot. At least 89% when surveyed say that campaign contributions are a problem, with 52% finding them to be a major problem. 76% of the public says that campaign contributions influence the court. But you know what is staggering? 80% of the lawyers say that judges are influenced by who contributed to their campaign, and more than half of the judges agree. When you realize that 85% of our state court judges all across the country are subject to some type of election, and that 95% of our disputes are decided by state courts, you begin to sense the magnitude of the problem. The most notorious state court race is one with which you are probably familiar. It involves the state of West Virginia, where a single individual, Don Blankenship, who was then the CEO of Massey Coal Company, contributed $3 million to elevate a lawyer, Brent Benjamin, to the high court. Now, Mr. Blankenship filtered his money through a 527 group, and the name of the group, bookmark this for later also, was For the Sake of the Kids. He was successful in ousting an incumbent justice, and following his swearing in, the man who Mr. Blankenship supported voted to reverse a $50 million jury verdict against Mr. Blankenship's company. Mr. Blankenship commented this way about his expenditure. He said, "I've been around West Virginia long enough to know that politicians don't stay bought." And the remaining comments suggest that he would never waste $3 million trying to buy a judge because it wouldn't serve him well in the future. Now, it is true, bringing us to the second case that I want to talk about, Caperton versus A.T. Massey Coal, that the United States Supreme Court, again in a 5-4 vote, found that the refusal of Justice Benjamin to recuse himself from sitting on that appeal violated fundamental fairness. It is true that the court ruled that way 5-4, but they limited their holding in such a way that it has had little impact on state courts. This single donor scenario in West Virginia is the exception. Most of the time, the big spenders are not individuals like Don Blankenship, but groups, including stakeholders such as corporations, unions, and others who do view the expenditures as a wise investment. And that brings us to the third case in the trilogy, Citizens United versus FEC. Don Blankenship didn't think that it paid to buy a court, but the President of the United States Chamber of Commerce put it this way: it's a lot cheaper to buy a state Supreme Court than it is to buy an entire legislature. So, while many candidates for judicial office receive modest donations from numerous sources, the bulk of the money comes from a small group of big organized spenders through 527 organizations with benevolent or patriotic sounding names like For the Sake of the Kids. Sometimes they have names such as Citizens for Better Government or Citizens for Fair Courts. And so one of the things I want to encourage you to do is look beyond the name of the supporting organization. Now, more frequently than not, the money flows from out of state. And basically, as you can see from this slide, which seems to be going away for some reason, I apologize, I'll skip through it. More frequently than not, the money comes from out of state. A case in point is Iowa, a state whose Supreme Court ranked 5th in the nation as the most trusted court, as graded by the Chamber of Commerce. Yet in 2010, after the court interpreted the Iowa Constitution to allow same-sex unions, millions of dollars were spent from out-of-state organizations to remove 3 of the justices, including the Chief Justice, from the court. So let me move forward to just 2 illustrations of how the money is spent. I don't mean to take too much time, but I'll be through in just about 4 minutes, I hope. The money is spent on television advertising. And the money is spent on television advertising in order to impact the electorate. And almost always, the ads use a provocative surrogate to rouse the emotions of the citizenry. And two illustrations will give me a nice segue into the citizens' role in protecting against the hijacking of our courts. This first example comes from Illinois, and it is an ad used against Justice Thomas Kilbride in that very expensive Illinois race that I talked to you about. He was part of a 4-2 majority of the court who overturned a state law that capped medical malpractice jury awards at $500,000. His opponents were the tort reformers in the Civil Justice League and the U.S. Chamber of Commerce. But rather than run an ad saying we want to cap jury awards, this is the ad that they ran to attack Justice Kilbride.
I was convicted of stabbing my victims with a kitchen knife.
For shooting my ex-girlfriend and murdering her sister in front of our child.
Of sexual assault on a mom and her 10-year-old daughter. Then I slashed their throats.
On appeal, Justice Thomas Kilbride sided with us.
Over law enforcement or victims.
Other judges overruled Kilbride and our appeals were denied.
Kilbride chose criminals' rights over and over again, way more than any other justice. Vote no on retention of Thomas Kilbride. Vote down ballot. It's a top priority.
As is often the case, they chose to label Kilbride as soft on crime. Now, $3 million later, Kilbride did retain his seat, but the opponents have promised to come after him again. This next ad is the one that causes me the most pain. This ad is from Wisconsin, and it is an ad in which the game plan was borrowed from Illinois. This is when the Wisconsin Club for Growth, another pro-business organization, decided that it would be imperative to get rid of the only African-American member of the Wisconsin Supreme Court, Louis Butler. They too were interested in tort reform, but their modus operandi was to play the crime card. But this time they played it with racial overtones. And if you would just bear with me, I want you to listen carefully and tell me what you think you know about Justice Butler after you hear this ad.
Unbelievable. Shadowy special interests supporting Louis Butler are attacking Judge Michael Gableman. It's not true. Judge, District Attorney Michael Gableman has committed his life to locking up criminals to keep families safe, putting child molesters behind bars for over 100 years. Louis Butler worked to put criminals on the street, like Reuben Lee Mitchell, who raped an 11-year-old girl with learning disabilities. Butler found a loophole. Mitchell went on to molest another child. Can Wisconsin families feel safe with Louis Butler on the Supreme Court?
Louis Butler was defeated by Gableman, who successfully defended against the ethics complaints that followed. The content of the ad was completely false. It suggests that Butler represented Mitchell and used a loophole to free him so that he could rape another person. It suggests that Butler may have heard the case as a judge, but he didn't. He represented Mitchell as a public defender appointed by the court to represent Mitchell. More importantly, Mitchell was never freed. In fact, he served his entire sentence and was paroled. And he did reoffend, but he reoffended after parole, not after a successful appeal. In fact, Louis Butler lost the appeal in which he represented Mitchell. Moreover, the ad, though misleading and arguably false, it was the Wisconsin Supreme Court and the Ethics Commission that they appointed who found that their new member, Justice Gableman, had not violated any rules in running that particular ad. Pretty staggering. So, are you concerned that special interest groups pressure judicial candidates to stake out positions on controversial legal issues? Most of the public is. These three cases have made a difficult situation more difficult. And I want to speak just in closing about what I would characterize as the equally bleak situation in your home state, as I encourage you to take over the citizens' mantle in preserving fair and independent courts. There have been three or perhaps four efforts to reform the Tennessee judiciary. You'll see a map of judicial districts on the overhead. The first effort was to completely redistrict the state, which would have affected many sitting judges, many long-standing, not only judges but prosecutors, many long-standing traditional boundaries within the state. That bill didn't make it to passage, except for 2 or 3 small districts that were affected. So that bill will be revisited next year. But you're probably all aware that as of now, the Tennessee court system is of 2 types. The appellate court system, the judges who sit in the appellate courts, the 29 judges who sit on the Court of Appeals, Court of Criminal Appeals, and Supreme Court, have been selected for over a decade, and the Court of Appeals for more than 3 decades, by merit selection. After nomination to a selection commission, which was for a time diversified and bipartisan, then the governor would appoint based upon 3 individuals coming out of that system. That system was coupled with one of only 11 existing judicial performance evaluation systems in the United States. We were only one of 11 states whose judges had said, help us be better judges, give us a performance evaluation the way other people on their jobs get. As of now, as of the adjournment of this year's General Assembly, those selection systems are no more. The Judicial Performance Evaluation System in Tennessee, of which we were so proud, we were the 8th state in the union to have such a system, is gone. So what we are left with is a legislature who believes that our present system is not constitutional, and who will have in 2014 a constitutional amendment with regard to a new selection system. That new selection system will have a merit function, but the approval and reapproval of the courts will not be by virtue of a yes-no ballot of the electorate, as it has been, but rather by approval of the legislature. We won't be the only state to have that. South Carolina has it. Some other states have it. But I just ask you to remember back to the days of George III and the concern about control by the executive, and wonder if that same concern exists with regard to control by the legislature. We also won't, as I've suggested, have performance evaluation, which was a real crown jewel of the Tennessee court system. The saddest thing about it is we have a darn good judiciary. We had nothing broken. There was nothing that needed fixing. Look, I'm the only person to ever be removed as an appellate judge in Tennessee or not be retained, and I can stand here and tell you we had a good system with a phenomenal number of judges, and we stand to lose that. So salvation can't come from within. It never does. Lawyers and judges talk about this and wring their hands all the time, but it's got to come from without. It's got to come from the concerned citizen. So I would leave you with 4 or 5 quick ideas. The #1 League of Women Voters initiative in your pamphlet is to maintain voter education outreach. And that is exactly the #1 way for the concerned citizen to help preserve the integrity of our courts. Look beneath the ad. Go beyond the rhetoric that you're hearing. Remember these 2 ads and ask yourselves, when you see judges being painted as soft on crime or anti this or that, is there a different agenda? Are you being manipulated? Is this a surrogate to try to get rid of a judge who's just tried to follow the law? So be circumspect as you view advertisements about judges and as you hear things about judges. Investigate the candidates. You won't have the evaluation system to help you, but take it upon yourself to investigate the candidates and do as you've always done in terms of having candidate forums, which I know it has been a wonderful addition to attempted fair elections. And speak out when you find that candidates have been wrongly portrayed. Speak out and help that word get out. Only by educating yourself and others about the true individuals who are seeking courts will we stand a chance, really, of preserving what was the blueprint of this democracy and what we must maintain if in fact courts are to remain able to be the great levelers. Thank you very much.